Good morning, ladies and gentlemen. As per the screen, I'm called Daniel Angwalia. I work with the law firm of Angwalia, Psik and Company Advocates. My colleagues have greatly discussed some of the aspects of my discussion. While growing up, I was told you start eating sugarcane from the top. But from what I've seen, my colleagues started eating sugarcane already from down, so now I have to bring for you the lesser taste. That is an overview of what I will take you through. What arbitration is, the basics. In brief, the basics: what's an arbitration, forms of arbitration, reasons for arbitration in construction disputes, briefly advantages of litigation, and then the gist of the discussion: role of court in construction arbitration. That is before arbitration, during arbitration, and after arbitration. Well aware that we are now hungry and therefore may need a break. I'll not take long in this presentation. As already discussed before, arbitration cannot be divorced from national courts. National courts are still involved greatly in the arbitration process. In many ways, at the end of it all, when you have your awards may be on paper if the respondent does not want to pay. So one or the other, you'll need the state machinery, and that is the court system, to force the other party to pay by way of enforcement. So what is arbitration? It is a consensual private process for the submission of a dispute for a decision of a tribunal comprising one or more independent third persons. In other words, before you can talk of arbitration, there must be an agreement between the parties that in the event a dispute arises, you will not run to court or use other means of dispute resolution, but rather you'll have it resolved by an arbitrator. An arbitrator may be an individual, one person, two, or more. It is very important that the agreement of the parties to refer the dispute to an arbitrator is clear, because it is in the agreement that the arbitrators or that the arbitral tribunal derives powers. The agreement has to be very clear, devoid of ambiguity. In arbitration, we call it pathological clauses. If you have an arbitration clause which does not make sense as far as arbitration is concerned. But what's important that you may have an agreement before a dispute has arisen. So you have a contract, and within the contract, you have what we call the ADR clause. That in the event of a dispute, the matter shall be referred for arbitration. Or you may have an agreement after the dispute has arisen. But look here, this dispute has arisen, let us not waste time going to court. Let us go for arbitration. But this is risky, because most cases when dispute has arisen, the parties are not even talking terms. It will be very difficult for you to reach out to the other party to have an agreement with you on how the dispute will be resolved. And most cases where there's a dispute, the parties for one has high bargaining power. In the context of construction law, the employer usually has high bargaining power. You find that it is you, the contractor, aggrieved with the decisions or actions or non-actions of or omissions of the employer. So you're not likely to bring them on the drawing board, make an agreement with you to go for arbitration. And between the contractor and subcontractor, the contractor has high bargaining power. So some of these things are better incorporated at the beginning of the contract. So if you don't have arbitration clause in the main contract, you can separately have arbitration agreement. What is common is that most contracts will have arbitration clause within the contract itself. So it's very, very important that when you are preparing this contract, that clause is clear, in that in the event of dispute, it will not be declared to be void or null and void. How does it arise? You have an arbitration clause which says, for example, in the event of dispute arising between the parties on any matter touching disagreement, the dispute shall be referred to an arbitrator in, say, in London, and or shall be referred to an arbitrator in London, and the decision of the arbitrator shall be binding and final and binding, and any party who is aggrieved shall refer the matter to courts. You know, arbitration in itself is final and binding. So once you have the arbitral, you have an award, say for a few exception circumstances, final and binding. So you cannot have a clause the effect that in the event of a dispute will be referred to an arbitrator, because this shall be final and binding, and if you are aggrieved, then you go to court. So what will be the role of court in that case? Another situation can arise where parties say the matter shall be referred to you. Let me give you an example. In the event of a dispute, our dispute will be referred to Uganda National Chamber of Commerce for arbitration, or the arbitrator shall be appointed by chairman Uganda National Chamber of Commerce and Economics or something. The point is referring to non-existent arbitral institution. You are saying that the event of a dispute, you will get this institution, Uganda Society of Lawyers, or Uganda Society of, the point is referring to non-existent institution, calling it to appoint an arbitrator. Such a clause will be null and void, of no legal effect. So it's very important. There are forms of arbitration. There's what we call ad hoc arbitration and institutional arbitration. Ad hoc, you're basically the two parties with a dispute reach out to an individual and say, look here, we have this dispute, we'd like you to resolve it. Individuals reaching out to, the parties reaching out to an individual to determine their dispute. The parties also determine the number of arbitrators, manner of their appointment, and procedure for conducting the arbitration. Now, because to the ad hoc, the parties may adopt, that principally we have the Arbitration and Conciliation Act, but to implement that, you need the rules that even that ad hoc arbitration is going to follow. But our rules are quite brief. So in the end, for proper or effective dispute resolution and arbitration, you need something more detailed. So the practice that parties resort to, you have two options. You may draft your own rules, which is not easy and time-consuming. Why would you do that? But rather, you prefer to adopt rules of an existing institution, or rules that have already been designed, prepared by experts, reviewed over time. And in these cases, especially when you're dealing with ad hoc arbitration, they prefer that the UNCITRAL model rules. They're basically designed to help in ad hoc arbitration. But parties are also free to select any rules that they wish the arbitrator to base on in the resolution of the issues. This kind of form is preferred where the dispute is involving small claims or small amounts of money, or the dispute is not complex. For example, any dispute which is less than $5 million is small dispute, and therefore it may not be necessary to go for institutional arbitration because it is more costly. Then we have the institutional. This involves the specialized institutions that intervenes and assumes the functions of aiding and administering the process as provided by the rules of that institution. You have to note that the institution itself does not arbitrate. If you have a dispute and refer it to ICAMEC, you are not calling upon ICAMEC or London Court of International Arbitration to arbitrate, but rather to administer. They can aid in appointment of the arbitrators. They themselves offer a secretariat where you file pleadings. You as the arbitrator, legal counsel, you file your pleadings, and then they have administrative staff that is responsible for distribution of those correspondences. So sometimes you may deal with a party who may not listen or may not respect an individual involved in ad hoc arbitration. But when correspondences are coming from an institution, then chances are higher that they will heed to it. And this is important, especially when you are dealing with the big disputes. Example, as I said, ICAMEC, that's for the case of Uganda. CADA also has some issues, apparently not constituted, but that is it. Why do we prefer arbitration in construction disputes? What are the justifications? You'll hardly hear a lawsuit involving these big construction companies or construction companies or handling construction projects of a reasonable magnitude. And you'll wonder, don't these guys have issues? How do they resolve it? They actually have issues, but their preferred method of dispute resolution is arbitration. Of course, this comes in after all the other stages have been exhausted, like through the dispute avoidance board, adjudication. Now, when things are failed, they go for arbitration. Our question is, why do they have preference for arbitration? There are some of the reasons or the justification for that. Construction projects are complex, technical, and associated with many risks compared to our ordinary commercial disputes. Now, when it is technical, you need technical people. You prefer technical people to resolve them. Now, technical people are easily selected through arbitration, in that the parties have a choice to determine who is going to hear their case. If we decide on engineer X, why are we picking him? We are relying on his technical expertise. And the other thing is that in construction projects, time is of essence. Late delivery has serious cost implications on the projects. Construction projects that are usually donor funded have completion timelines. You need faster means of dispute resolution, because if you delay, then the cost will escalate. We know our ordinary court system. Our ordinary court system is facing challenges of backlog. They may not have the time to urgently resolve their dispute. And given the time implications, it is preferred arbitration be the method for this resolution of dispute in the construction matters. Many parties are involved in construction projects. For example, we have the employer. Let me give you an example of a road project. You have the employer, in this case, government of Uganda or UNRA. Through UNRA is the employer. You have the main contractor. The main contractor cannot execute the work alone. The main contractor has to bring in subcontractors. It's not going to bring just one company. There are going to be hundreds, because there are several components of a big construction project, say a road. You are going to bring a subcontractor who is going to supply with the aggregates or going to construct some sections of the work as being directed now under the BUBU policy. You need experts who are just going to deal with the lifts, big machineries, specialized in that. You also need, you also have financial institutions. Here we look at the donor, the funders funding the head project, and then your service providers, are also financed with reliance on the contract that you have with the employer. So if you take disputes slightly, a single dispute with one of the stakeholders can trigger disputes in the entire chain. Okay? So with this this unique arrangement is not suitable for ordinary court system to resolve. You prefer stakeholders or players who understand the industry or have the expertise. And then the other is use of standard forms of contracts. My colleagues have been referring to FIDIC. When you talk about FIDIC, there are over 5 different forms. They're used for different projects, depending on the risk allocation, the nature of the project, the magnitude, whether there are involvement of donor agencies. Now, these documents have been drafted for many years, have been reviewed over time. We have people whose life has only been on FIDIC. That's all they know. In the event of a dispute arising out of these standard form contracts, you'd be more comfortable having these experts address your dispute. And also the beauty of arbitration is that you can have 1, 2, or more. You can have up to 3. Not the case with the court system. Court system, however complex the matter is, you are still going to end up before one judge. There's a saying that 2 brains are better than 1. So where you have very complex dispute, you prefer to have the matter determined by an arbitrator who may be a technical person familiar with the subject contract or subject matter. Briefly, advantages of arbitration as opposed to litigation. It's faster means of dispute resolution. We are aware of the backlogs. Okay. And with the timelines associated with this project, the donors have given the government money to use this, to construct this road in 4 years. After that, the money will be used for something else if you do not use it. So you don't want to go and spend many years in the court system trying to resolve a dispute that can be resolved in 3 months. The party is able to appoint an expert in the subject matter. You know, you're not taking chances, a very serious matter to go before a judge. You know, it is true. There's an assumption that judges know everything. But the reality is that they're also human beings. You can't know everything. The laws are changing each other time. There are new areas which are developing time and again. You find if the judge was in a family division for 10 years, or any other division for that matter, for 3 or 4 years, taking him to a commercial division and presenting a complex international construction dispute, well aware that this has to be resolved within the shortest time possible, you are not likely to get the desired result. You are better off having it resolved by experts. So that's the advantage. Also, parties are in position to choose experts of their interest. And also you can choose a dispute resolution procedure which addresses your challenges at hand. You see, in arbitration, unlike litigation, we have the liberty to proceed as we wish. You know, even as much as in the process at the beginning, when the dispute has arisen and you have identified the arbitrator to hear your dispute, as parties, you can always agree and modify the rules that you have selected. You may agree that, well, the nature of this matter, we think can be resolved just by use of documents. And by submitting documents, you leave the arbitrator to make a decision. That's not the case with our ordinary court system. You will file the suit, serve after that, the summons for direction, file trial bundles, stories. With the arbitration where you have chosen that trial by way of submission of documents will be sufficient. After filing, the both parties have agreed, You submit your respective documents, wait for the arbitrator to review and make a decision. When you go to court, you have to go by the ordinary system as set out by the existing rules. With arbitration, also confidentiality. You find the best example in the condominium project, for example. This is the project going to, you have like maybe 300 housing units, and the issues to do with the design, the quality of works, which is before an arbitrator, okay, this is before an arbitrator. The arbitrator will handle it professionally. The players within the arbitration framework know it. Confidentiality is very, very important. Even as you handle documents in your office, as legal counsel involved in arbitration is very important. Because if the clients get to know that something very confidential leaked from your office, then you're going to have problems. Now, if there are defects in an existing structure, you're dealing with several buyers here of the houses you have constructed. If one of them gets to know that there are issues with the design, the quality of works, how is it going to be? You may not actually get buyers for your project. But that does not mean that there are no disputes in these things. There are disputes, just that they are handled confidentiality, with confidentiality. So that's an advantage, unlike litigation. You know, nowadays, as soon as the judgment is delivered, I think even before the judge leaves his chambers or the courtroom, as long as he has signed, the judgment is all over social media. Doesn't matter if it is good or bad. That does not apply with the arbitration. Unlike, save for circumstances where the parties are very good at, okay, let the decision of the arbitrator be made known, which is very, very rare. That only applies in an arbitration involving, say, state parties in the disputes of public importance. The other very key advantage is that with an arbitral award, you can be able to enforce it anywhere in the world, as long as one of the parties or the parties from a country that's a member to the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. It is true you may do the same with the ordinary judgments, but with arbitration, there's a special recognition. You can easily enforce it. Now, the gist of the presentation of my task here, the role of the court in a construction arbitration. As I pointed out at the beginning, you cannot divorce court completely from the arbitration process. You may, if you are lucky. You have gone through the arbitration process, you have your arbitral award, the respondent who has been ordered to pay has paid. Good for you. The matter will end there. You don't need court. Other instances, even before you reach the stage of getting the award, you find that you need court either before, during, or after arbitration. Let us look at the role of court before arbitration. I deliberately selected case law from Uganda to show our audience that arbitration is real, it is being practiced in Uganda, and we can grow it, given the advantages already mentioned above. Stay of legal proceedings. Section 5 of the Arbitration and Conciliation Act provides that a judge or a magistrate before whom proceedings are being brought in a matter which is the subject of an arbitration agreement shall, if a party so applies, after the filing of a statement of defense, and both parties have been given a hearing, refer the matter back to the arbitration. Now, I'm not telling there has to be a valid arbitration agreement between the parties. I talked about those components of a valid arbitration agreement. In arbitration, we avoid what we call pathological clauses, something that is not valid. So if, assume you are the judge and the matter has been brought before you, and from examination, there's an arbitration clause, ideally this matter should be before an arbitrator. but it has been brought before you. The Act says upon application by one of the parties and hearing the other parties. To me, I think where we are heading, the judge should be at liberty to even refer the matter as long as there's an arbitration clause. Why would I sit when I've seen from the contract that there's a very clear valid arbitration clause, then I sit and wait for one of the parties to make an application? I should have the liberty to exercise my powers and refer the matter straight to arbitration. I think that's where we should be heading, and hopefully we can have a bold judge to bring that to play. In this case of power and city contractors versus, you can see, just save time. Justice Musota has even held that an arbitration agreement has a binding effect on the parties. And my concern is that if it has a binding effect on the parties, why would a judge first wait for an application to be brought before him, then call upon the other party here, and then refer the matter? They should be given the discretion, and in other jurisdictions where arbitration is highly developed, like the UK, Singapore, Hong Kong, they have the powers to send the matter. But let us go on and see what has happened. In another case of the second case of Yanjian Uganda company, the dispute was sent for arbitration in accordance with the arbitration clause in the agreement between the parties. It's somehow obvious, as long as you can see that, yes, as a defendant, that is, or that you can see from the arbitration agreement or arbitration or dispute resolution clause in the contract, which is the subject of the suit. The agreement is clear. Make an application to the judge or magistrate is more obvious that it will be referred, subject to the agreement being valid. Now, in that same case, court guided that failure by one of the parties to afford the fees of the arbitrator was not an excuse to depart from the clear provision of the agreement which provided for arbitration. This is a challenge. Usually when drafting these agreements or arbitration clauses, as lawyers, we don't take, it's unfortunate, we don't take it seriously. You just copy and paste. You just copy a provision and paste. You have not seen the capacity of your clients. But with the construction disputes, the parties have the capacity. Not usually an issue. They usually have the capacity to afford an arbitrator. But I'm diverting slightly to ordinary disputes, contractual disputes. If you're faced with a client and you're drafting for them an agreement, don't just copy and paste, especially after this training. Consider arbitration clauses to be very serious. It is true, arbitrators are expensive because they're private judges. Okay? You can file a matter before any judge and it's for free, subject filing of, payment of filing fees. Now, imagine a situation where you have inserted a clause in a contract involving parties without really the means to afford an arbitrator. We have had this reasoning argument raised by many lawyers. You see, the parties, they don't have the means to afford an arbitrator. Let this matter be heard by court. Courts have said it's material. If the parties have agreed, arbitration agreement has a binding effect. So we have a duty. See the people before you. Can they afford an arbitrator? Is the kind of dispute worth sending to an arbitrator? Because at the end of it all, should any of the parties raise it, then it will be sent. And usually, as I said, in a contract, parties don't have equal bargaining power. In a construction contract, the employer has high bargaining power. The main contractor has high bargaining power. Chances are high that it is the person with the low bargaining power who has filed a suit against the contractor or the employer. And therefore, as counsel for the defendant with the deep pockets, what will I do? I'll make an application to have the matter referred to arbitration. And we have done it several times. It is quite obvious. As long as you, at the time of your making the application, you have valid arbitration clause. The issues of fees are things of the past. Okay? That's one. Two, when drafting this, consider the magnitude of the dispute, potential dispute, or the money involved. Don't say in the event of a dispute, you may actually be faced with a valid arbitration clause, but you have said that in the event of a dispute, it will be referred to ICC. Why would you do that? A dispute is 200 million, and you're sending your poor client to London. This man has never even been to Kenya, and you're telling him to go to London. You know what it means going to London? He has to get a visa. Does he qualify for visa? Can he afford the lawyers? You know, the beauty of the arbitration also is that you can practice from anywhere around the world. You may still have the lawyer in Uganda, okay, who will go and file the matter if he has the knowledge and the training or the experience, who will go and represent him or represent the party in London. But to just filing fees, ICC, is $5,000. What are the chances that we'll be able to afford? Those are some of the things you have to consider as we are representing these parties. Further, in the case of Ambitious Construction versus National Theatre, the suit was terminated once the matter had been referred for appointment of an arbitrator. You start to accumulating costs for your client. And in this case of Sobetra, the plaintiff was penalized for filing a suit in the High Court. The reason was that the provisions of the Arbitration and Concession Act, providing for reference to arbitration where there's an agreement to arbitrate, is mandatory. And the plaintiff sought to file a suit in the High Court, well knowing that there's an arbitration clause. So we are seeing the role of court as far as staying of proceeding is concerned. So don't just go and file a case when there's a clear arbitration clause. I know the challenge we are having is the training. And we see this a lot. You serve your colleague with the documents. You have actually properly commenced arbitration in accordance with the act or in accordance with the rules agreed on by the parties at the beginning of the contract. You expect the other party to respond in an arbitration manner, but then your colleague will write to you, we don't recognize arbitration. How? Why did you include it in the agreement? These are things we face. So you scratch your head, you first leave aside your client's case and educate your colleague. I have had to do that several times. The council, with due respect, just give me 30 minutes. I brief you what this is. So hopefully with the capacity building, we shall get to understand what arbitration is and the practice of arbitration. It's not a question of saying we don't believe in arbitration. The question is whether there's a contract before you. There's a dispute. I'm going forward. The guy will tell you, no, we are going to pay. Give us some time. We understand those letters without prejudice. Doesn't help, because just like court system, if I've commenced the arbitration process, say good enough if it is ad hoc, I mean institutional arbitration, I'll proceed with the appointing authority. The appointing authority will guide and appoint an arbitrator. Whether or not you participate does not matter. At the end of it all, they will hear me and I come out with an award. As you're playing tricks, my intention is to get the award and enforce it. So also when you are drafting this arbitration clauses, it's very important to consider the parties you are dealing with. In the event of a dispute, this is the kind who's likely to respond to ad hoc arbitration. Of course, there are more challenges when you are dealing with the uncooperative party in ad hoc arbitration, because you are left stranded how to go about the process. But with the institutional, in the event that the other party does not cooperate, the rules are very clear on how you proceed. The other role played by the court before arbitration is when it comes to interim measures. Section 6 provides that a party to an arbitration agreement may apply to court before or during arbitration proceeding or arbitral proceedings for an interim measure of protection, and the court may grant the measure. Note that interim measure is broad, and those may cover things like temporary injunctions, attachment before arbitration, deposit of security for cost, discovery. But discovery may apply during the arbitral process. But now let us look at interim measures before. You have not yet commenced arbitration, and you see that the subject of arbitration is going to waste if I don't go to court to get protection. That's where we have some case law look at. In the case of Swabri al-Abubakar versus Kobil, court has to ascertain whether there's a valid arbitration agreement, because it is the arbitration agreement that gives powers to the arbitrator or arbitral institution. Before court can hear you in an interim manner, it has to be very clear that there's an arbitration agreement between the two parties, and dispute has a reason. So these are documents you'll be attaching in your application, say if you're applying for a temporary injunction. Okay. And the court is supposed to only act in the interim. So if there's a provision allowing, so assume you have already commenced the arbitral process, and the tribunal has powers to rule on some of the things you seek from court, it is advised that you first present your issue before the arbitral tribunal, and after it has failed, then you proceed to court seek for that assistance. In the recent case of Zander, we limited another versus game discount store. Court declined to grant the application for injunction, restraining the respondent from disposing of stock in game store pending arbitration. Before we commenced arbitration, we went to court. There was a dispute. I can't discuss the details here, but there was a dispute involving the parties. Zander will and another sought to buy game. You all know game is no longer in existence. And game was comprised of stock. As we were discussing the issue, as the dispute was, of course, escalating, so look here, our intention was to buy game stock. But they were seeing game has now advertised that's closing. It's even disposing of items at discount. So we got worried. We went to court for an injunction to restrain the sale. However, court declined, saying that we filed the application late. You know, sometimes the court system also frustrates the process. You file, you wait for the registrar to sign, you serve the other party. If the party is out of jurisdiction, then you have to seek court's leave, to serve out of jurisdiction. By the time you come back, you have lost close to a month. And if you are seeking to protect something which is on sale, on discount, what's the chance that by the time you even get a decision, you'll be safe? So even from the time you close the submission, another maybe 1 week or 2 weeks to write the ruling. So court also has advantage and disadvantage, one way or the other. And that's also basically because of the system. But the law is clear, you can apply to court for that relief. And in this particular application, court considered criteria for grant of application for interim order in civil matters. When you make application for temporary injunction in civil matters. Previously, in arbitration, we would try to distinguish arbitration that be distinguished from ordinary civil practice. But here, I think the judge looked at the fact that you are before court. And when you're before court, courts are liberty to apply all the laws applicable to it. The Judicature Act, the CPA, CPR. But the most important thing that you have to apply to court for that interim order, injunction. Court's role is to grant it once you prove that there's a valid arbitration agreement and you meet the criteria that is usually applied in matters of application for temporary injunction. And importantly, it has within reasonable time, because if you go when it is late, then you'll not succeed. But just know, it's not just about interim injunction. There are those other reliefs that you can seek from court before. The other role of court in construction arbitration is appointment of an arbitrator. We are aware that Section 9 is quite clear. No court shall intervene in matters governed by the Act. We're also aware the Act provides for appointing authority, that Center for Alternative Dispute Resolution. But as it is on structural challenges at the moment, there was a decision from Constitutional Court that the powers of CADA are supposed to be exercised through by the council and not the executive director, as the case was before. Now, considering the slow process of government, the council has not yet been appointed. And not appointing the council does not mean that disputes have stalled. No, the disputes are continue to emerge. And therefore, CADA is expected to work. Unfortunately, it's not constituted. Now, under such circumstances, what do you do? If in your arbitration agreement arbitration agreement or the ADR clause provided that CADA will be the appointing authority, and the appointing authority is not able to do its work, do you fold your hands or turn to Jesus? No. As lawyers, we are supposed to go beyond that. Court can be approached to exercise its inherent power to appoint an arbitrator where one of the parties is reluctant or uncooperative in the appointment process. Now, I'm going to discuss these two in the subsequent page. Now, in ambitious construction versus National Theatre, the applicant sought the assistance of court to appoint an arbitrator for the reason that the respondent, National Theatre, had not been cooperative in the process of appointment of an adjudicator. In the previous presentation, they told you the first step is an adjudicator. Where you fail, you go for adjudication. Where you fail, and you go for arbitration. Now, CADA was not cooperative with the ambiguous construction when the dispute arose and they needed an adjudicator. There were correspondences, they wrote to UIPE to nominate an adjudicator, nominated, they refused to say anything. So ambiguous construction was left wondering, what do I do? They went to court. Court recognized that under Section 9, it can only be involved in matters where it's allowed to do so. And in this case, the right party to do what's supposed to do was CADA, to appoint an arbitrator. But also court realized that CADA is not fully constituted. And the ambiguous construction had done its part in getting the respondent to cooperate with the appointment of adjudicator. So what court did was to appoint a firm of practice conflict resolution to appoint an arbitrator, noting that the parties did not make any proposals as to persons suitable to undertake the task. What does this mean? Ambiguous construction went to court, appoint for us an arbitrator. But court said, no, you did not provide proposals or persons suitable to do this job. Instead of appointing, it delegated or directed Practice Conflict Resolution Center to appoint an arbitrator. It could have done that, could also have asked ICAMEC to do that, but asked this particular firm to undertake the task. I think also consider okay, I'm not going into that bit of what Practice Conflict Resolution Center is. So court would have appointed an arbitrator on its own from the reasoning of the judge. Mean that if the parties are given proposals, it would have appointed. But this itself also is problematic. If the other party is not cooperative within appointment of adjudicator, I go and sit with them and say, let us propose the judge an arbitrator to handle this matter. I doubt. Despite that, I would still apply the court, ask court to either appoint or nominate an alternative institutions. You can give alternative institutions. Can be ICAMEC or Praxis, then court decides which one to send, which one to direct to make the appointment. Of course, if you are not in talking terms, you are not likely to ask the other party to sit with you to determine who to consider for appointment. Now, during the arbitration process, under section 16, we have what's called the doctrine of competence in arbitration. What basically means that the arbitral tribunal has powers to rule on its own jurisdiction. One of the parties may challenge the jurisdiction of, first of all, the arbitral institution, the arbitrator or the arbitral tribunal derives its powers from the arbitration agreement between the parties. But there may be instances where you challenge or you think, no, this particular arbitral tribunal or arbitrator does not have the jurisdiction to hear this matter. And you bring to their notice or to his or her notice if it is ad hoc arbitration where you have one arbitrator. And then the first thing is, the principle is that the tribunal or the arbitrator has powers under the law to make a finding in the first instance whether it has powers to rule on, whether it has powers to handle the arbitration matter before it. Now, if you are dissatisfied with the decision of that arbitral tribunal, you can appeal to court challenging this decision to the effect that he has powers or he has jurisdiction in the arbitration. As a matter of procedure, you have to apply within 30 days from the date the tribunal rules that it has jurisdiction to hear its matters. And the decision of court on that appeal will be final and not be subject to appeal. Okay? You just have to know that as you are going to court to appeal, the tribunal remains with the powers to hear the dispute and can go ahead up the point of determining it and even issue an award. So this is also problematic. If I'm challenging your jurisdiction to hear the dispute, and you know very well I've gone to court to appeal against your earlier orders that you have jurisdiction to hear the matter, would it make sense to continue hearing the matter? Well, knowing that court may as well rule that indeed you don't have jurisdiction, but that is the law. You know, in matters of arbitration, parties, it is party-led. So as parties, you can decide that, okay, pending determination of court on the issue of jurisdiction of the arbitral tribunal, let the process be halted until we have a finding from court on whether the tribunal has jurisdiction. After all, the decision of court is final and not subject to appeal on that issue. Then court assistance in taking evidence. Under section 27, the tribunal or a party with the approval of the tribunal may request from court the assistance in taking evidence, and court may execute that request. Why would you go to court? You know, arbitral tribunal lacks the enforcement mechanism. Court has the backing of the state machinery. You may require evidence from high-profile individuals, and that individual is not likely to respect a summons from ICAMEC, or in the case of ad hoc arbitration, writing to some general in Bombo, you are required to give evidence in this case. Please come on this day. Not likely to respect that. So once you see, depending on the circumstances, you want that witness to come, You can go to court and seek court's assistance. Court summons, of course, you must have grounds why you are seeking the assistance of court. Then court will be the one to summon the witness, with this machinery. Chances are high that the witness you want to give evidence is going to respect court. Because if the case does not respect or does not respond to summon, there are implications, no contempt of court and all that. That's why you'll find that court's assistance is necessary. Court will proceed to take the evidence and then forward the arbitral tribunal. And that it is task at that time will come to an end. Determination of question of law arising in domestic arbitration. What then is international arbitration? I need to put a distinction here. Domestic arbitration is when all the parties are from Uganda or from the same country, both the plaintiff or the claimant and the respondents. The moment one of the parties from another jurisdiction can be classified as international arbitration. Now, under Section 38, where the parties have agreed that an application by any party may be made to court to determine a question of law arising in the course of arbitration. In the process of hearing, a question of law has arisen, and as the parties, you doubt the arbitral tribunal's power or knowledge, expertise to make a proper finding on the question of law. You may apply to that tribunal to look here. We prefer this question of law to be determined by court, and whatever finding court will provide, the arbitral tribunal will follow it. So the advantage again with arbitration is that it's party-led. Once you have agreed, most cases will be granted. The arbitral tribunal will rarely go against the wishes of the parties once the parties have agreed on a subject matter. I've not seen it where as parties we make a request or an application or after agreement. In most cases, the arbitrator will grant, because if it does not, that can be an issue subject of setting aside arbitral award in case any of the parties are aggrieved. So, upon the application of by any party, you make an application to court, usually it's chamber summons. Court makes a finding on the question of law, to remit back to the arbitral tribunal, and then tribunal proceed with the hearing of the matter. Okay? So court will usually grant that, because as a matter of fact, it is the interest of both parties, both the court and arbitration, that litigation should come to an end. So it will not drag anything that's likely to delay the process. Then the other aspect after arbitration is the setting aside arbitral award. If you are disgrantor, aggrieved with the decision of the arbitral tribunal, you can apply to court within 30 days from date of receipt of the award. The grounds are many, but you have to know that it is an uphill task to have an award set aside. Courts are very reluctant to set aside an arbitral award, because in the first instance, you agreed on the arbitrator. You show him or her, you believe in his or her expertise, he has rendered a decision. Why are you running away from it? So you have an appeal task to convince court that really there are justification for court to now come in, delve into your matter, and set aside. And bearing that in mind, courts are also very strict when it comes to timeline, because they do not want it. So before you consider make an application to set aside the arbitral award, look through it carefully. Okay? One of the grounds, or there are many grounds, one of them is that a part of the arbitration agreement was under some incapacity. Now, how do you wait after the tribunal has had this matter, maybe over a period of 7 months, to say now I was incapacitated, I want to set aside? Sure, you have an appeal task to prove that ground. And the other one, that the arbitration agreement is not valid under the law to which the parties have subjected it to, or if there's no indication of that law, the law of Uganda. Again, with arbitration being party-led, we can all be Ugandans, or the parties can all be Ugandans, and say our arbitration, the laws applicable will be, say if the contractual dispute, law of contract of South Africa. You see? The other one is the party making the application was not given proper notice of the appointment of an arbitrator. You have an appeal task. How did you participate in all this if you're not given notice of appointment of an arbitrator? Yet you must have grew an arbitrator in the first place. That the arbitral award deals with the dispute not contemplated by or not falling within the terms of the reference to arbitration. You take a different matter for arbitration, and the arbitrator comes up with different issues altogether, not related to what you took before him. The composition tribunal or procedure followed was not in accordance with the law. The award was pursued by fraud, and you mean the award is not accordance with the act, is in conflict of public policy of Uganda. In the NSF versus Alco International, the Supreme Court set aside an arbitral award which found to have been pursued by fraud contrary to public policy. The matter was thus remitted back to the High Court for trial. You can imagine, you go to an arbitrator, here's the matter, you are aggrieved, Court of Appeal, Supreme Court, High Court. How many years are those? It's unfortunate. I mentioned that when it comes to setting aside arbitral awards, courts are strict on timelines and the mode of application. Just passing through in one of the applications, court set aside it. Instead of an application to set aside, this particular party filed an appeal against the decision of the arbitrator. We say it is final and binding, so you cannot file an appeal. Okay? You can only file set aside. And also has to be within 30 days. So in that particular case, well, it was unfortunate for the client, and therefore did not succeed. In local construction, application made after 30 days is a nullity. You can also look at Babcon Uganda Limited versus Mbala Resort. I also talked at the beginning advantage of arbitration over litigation. The awards can be enforced in a part of the world, and one of the roles of the court is enforcement, recognition, and enforcement of an award. Once you have received your award and the other party is not paying, if you have to do with payment, you can go to court. And one of the requirements, you submit the original arbitral award or certified copy of it and the arbitration agreement. Because much as you may have the award, if court looks through and finds that the arbitration agreement was not valid, then it will not enforce the award. Okay? In that particular case, the judge observed that courts strive to uphold the arbitral award. They do not approach them with a meticulous eye, endeavoring to pick holes, inconsistencies, and faults in awards, but with the objectives of upsetting or frustrating the process of arbitration. So, unlike before, the practice now, courts really try as much as possible to uphold awards, and they have raised very high standard when it comes to proving any of those grounds for setting it aside. Okay. So they have to read it with a reasonable and in a commercial way, expect that there will be some faults. Arbitrators are also human beings, and therefore minor faults here and there should not necessarily be a ground to set aside. In the Mbala Resort, they also observe that it's final and conclusive. Courts have to approach with the desire to support the arbitration process. Ladies and gentlemen, in conclusion, I wish to state that we play a big role in drafting arbitration agreement or dispute resolution clauses. We should draft them so well so that the parties' intention to have their construction disputes arbitrated are upheld and not frustrated by pathological clauses, because they don't know these things. It is our duty to do the right thing. Okay? Some parties trying to use court intervention to delay the process, because that's their lawyers. He files an application set aside, very well knowing that his client is supposed to pay, and the decision is quite clear. Now you file an application and push to fix it 2 months away. On the date of hearing, an excuse, another month. So that is the abuse of the process. As lawyers, we should desist from that. Arbitration has high potential to address complex construction disputes and to deal with the backlog in the court system. As lawyers, we can still earn handsomely while representing parties as arbitration counsel before arbitral tribunal. It has many advantages. This practice of saying we don't believe in arbitration. No. Once you know arbitration and you bill the client who knows arbitration, they'll pay you because they know it is in a way specialized kind of practice. Not anyone can be able to do it, but with the capacity building, we can learn this. I'm the country representative for Africa Construction Law. It is an initiative of construction law players within Africa and the diaspora to build capacity. And we usually organize these trainings, can go for a period of, the last one was for a period of 8 weeks, only on weekends, 3 hours, 8 weeks. That's capacity building. By the end of the course, you come out different. And it's through those engagements that you pick interest in studying further, appreciating the subject. So that we make arbitration a success and help the court system by reducing on backlog. Thank you for listening. Good afternoon.
Thank you very much, Mr. Nguria, for your good presentation. I think we've come to a conclusion that this symposium has brought the best. I think it has brought the best, and there is value for money. I would want to think so. I leave that to the assessment of the participants, where there is value for money in today's and yesterday's presentations and the quality of presenters. I will not waste a lot of time. Members online, are you still there? Okay, very helpful capacity building on arbitration. Thank you. Okay, fine. Looks like all is well. I don't see any request for the write-up because I think it was elaborate, and we'll share the presentation with all the authorities quoted therein. Nothing will be deducted. So there'll be value for money. We now shoot questions quickly, if you have any questions. Mr. Rutiba, you have one? Okay.
Really, thank you very much for your excellent presentation, Council. I'm just asking about the different bodies that do arbitration in Uganda. When you talked about praxis, I Googled it here. Then I think I'd heard about the individuals involved, and I don't know, just for the education of everyone.
Thank you. Initially, we had only CADA, okay, the Center for Dispute Resolution, as recognized under the Act. Subsequently, that was as the appointing authority. Subsequently, ICAMIC, with the initiative of Uganda Law Society, Uganda Institute of Bankers, also was appointed as the appointing authority by, I think, the Minister of Justice and Constitutional Affairs. The last time I checked, Praxis was also trying to get that authorization. I don't know if as of now they're authorized to do that, but I think also the land judge in that case of ambiguous construction would also have considered the person behind Praxis, because Praxis is, I think, a firm of the former Chief Justice, Bart Katrebe. Could rely on the fact that someone of that magnitude and reputation to make a good decision on who should arbitrate the matter. But that's the position as of now. Thank you.
Okay, thank you. Any other question before we shoot? Okay. Online, we don't have anything. Okay, fine. We have nothing. Maybe just for you to comment, Mr. Angulia, what's the criteria for appointment of arbitrators, or how does one become an arbitrator, or how do you get visibility as an arbitrator?
Thank you. The criteria for appointing an arbitrator should go back first to the agreement of the parties. Because when a dispute arises, or first of all, before even a dispute arises, the arbitration agreement should clearly state that in the event of a dispute, this matter shall be arbitrated on by either one arbitrator or two. And then they may also agree whether the arbitration will be ad hoc or institutional. Now, if it is ad hoc, it means that all times they must sit when a dispute arises and agree on who should arbitrate their matter. Now, when that arises, especially where counsel is involved, the first party who wants this matter, knows thing now a dispute has arisen and the dispute needs to be arbitrated, takes initiative after giving notice of arbitration, and you propose arbitrators. Now, when you are proposing arbitrators, you are looking at someone with knowledge, experience, and expertise in the subject matter, that's the subject of the dispute, to hear it. Of course, you would prefer that person who has knowledge in arbitration, for example. If you're having an engineering dispute, now we have a good number of engineers who have, they are, apart from being engineers, they have also done master's degree in construction law. You'll be surprised. They are members of Chartered Institute of Arbitrators, UK. They are in the panel of different arbitration institutions. Now that is ad hoc arrangement. I propose that let's stand so, hold this qualification, arbitrate this matter, and I give it to you. On your side, you may also propose. After you propose, you may agree or disagree. That's ad hoc arrangement. But where there's an institutional arrangement, these institutions have arbitrators in their panel. If you have said that, now, for example, with the ICAMEC, all other institutions I know, you must be a member of the Chartered Institute of Arbitrators, UK. You do that course, sit exam, pass it, and become a member. It is quite intensive, but at the end of it all, it is worth it. Because with the beauty of arbitration, you can be in the panel of Chartered Institute of Arbitrators, Uganda, the one of, not Chartered Institute of Arbitrators. Okay, that's one of them. You can say Uganda, Chartered Institute of Arbitrators, Uganda chapter may also have a list of its members. You can be on the list of the panel of ICAMEC, or any part of the world, Nairobi, Kenya, Nairobi, Kigali, Lagos. Okay, you apply once you, the basic requirements actually being a member of Chartered Institute of Arbitrators, UK. You are there. Now, when a dispute arises, and in the agreement, you agree that in the event of a dispute, ICAMEC or that institution will appoint. You present the institution, the practice that the institution will give you alternatives. Institution knows that this subject matter, given its magnitude, the complexity, counsel so is better placed to hear it because he has qualification in this area. He has handled matters of similar nature. So the institution will give the parties 3 individuals, will nominate 3 people, and then you pick one. The challenge when you pick different people, then the institute can come in and appoint for you. Now, on the issue of limelight, the first thing I think is to do the training. You need to have the knowledge, the intellectual honesty. It is not an area you're going to gamble. You are either a member of Chartered Institute of Arbitrators UK or not, because your membership can be verified. Once you are a member of Chartered Institute of Arbitrators UK, Chartered Institute of Arbitrators Uganda will know. We had a matter where the parties agreed that in the event of a dispute, the chairman of Chartered Institute of Arbitrators Uganda shall appoint, that was ad hoc arbitration, shall appoint the arbitrator. And then when the dispute arose, we wrote to David Kagwa, and they appointed the arbitrator. There was no choice that we shall decide, we shall have options. And I think it is even faster. You leave the institution to appoint for you. not giving you options. That drags the process. So once you have done the training, you are in the panel, and the continuous capacity building. And then, importantly, you deliver the integrity. The players within the sector will know you. The arbitration practitioners, we know each other. I know what you can do. I know what David can do, what Herbert can do. So if I'm an arbitration counsel in the dispute, I'll definitely advise the client, let's so arbitrate this matter. Thank you.